Dr. Bagby-Young, who will be presenting today on DNR and Advanced Directives. Dr. Bagby-Young is here as a temporary worker retiree. She was our former DDS Director of Nursing. Her incumbent, Gloria Jones, is our current Director of Nursing, who's also here today. Dr. Bagby-Young is a licensed psychologist. She's a board-certified family nurse practitioner and a psychiatric mental health nurse practitioner. So in addition to her 10 years practice as a licensed psychologist, she also has 39 years experience as a registered nurse. We are very grateful that she's taken the time away from her busy practice to present for us today, and we're looking forward to that. So thank you, Dr. Bagby-Young.
Thank you. And I too am going to turn off my camera. So thank you, and I'll get started. This is the DDS DNR review process and advanced directives. The purpose is for compliance with Connecticut legislation that protects the rights of individuals with intellectual developmental disabilities, and to also advocate for this vulnerable population. This is a population of protected persons based on their intellectual disability. There is legislation that speaks specifically to changes in code status, and a copy of that legislation should be in the packet that you received. I believe it was a PDF or a PowerPoint document, but I've highlighted certain changes. In 2018, Commissioner Jordan Sheff and I went to the legislative office building and requested certain changes to the existing legislation. So these changes were implemented in October of 2018. The primary change was that the previous legislation stated that only a physician could write the order for a change in code status to do not resuscitate or anything else. And the Department of Public Health changed that legislation in 2016 to allow advanced practice registered nurses who are the same as nurse practitioners. The two are the same. All nurse practitioners are advanced practice registered nurses, but then a nurse practitioner can specialize in certain areas. So this allowed nurse practitioners or APRNs to write the orders. And then we still consent with the person of the legal guardian of the individual. And in order to change their code status, the individual, if they are not adjudicated means that they have a legal representative. If they're not adjudicated, they can consent to their own changes in code status. Otherwise, it has to be somebody who is legally authorized to make that decision on their behalf. And then the person has to have a terminal condition, and terminal condition can be somebody who has cancer, somebody with septic shock, and they are in the hospital and usually going to die, within a matter of hours. It can be someone with severe dysphagia and recurrent aspiration pneumonia to the point that the dysphagia is not going to get any better and they are going to continue to aspirate. And this is somebody who who enjoys eating or might want pleasure foods. So it is very broad. So don't just think of a terminal condition as somebody who is actively dying. It can be people with chronic kidney disease or kidney failure or a number of other what are considered terminal diagnoses. And then there has to be a second opinion. And this section changed as well. So that second opinion can be a licensed physician or an APRN. So that was another change. The person is in the final stages of the condition. And however, if the medical professionals are not able to state that they are going to die within days or weeks, they would still be able to have a DNR order in place. It changes a little bit for the department, but when death is not imminent, and I'll speak about that later. But that's in there. And then the commissioner reviews certain changes in code status, and certain ones he or she is not required to review. And then we added this last clause that this legislation does not apply to individuals with a legally valid advanced directive. or a living will, either one. So those were the changes. Our DDS commissioner or commissioner chef has oversight and monitoring of the medical care of all persons that are placed under the direction of the commissioner in the department. In limited circumstances, the commissioner can authorize the commissioner or a designee, and that designee is usually a regional director. They can authorize urgent or emergency medical treatment, like a surgery or something, if a guardian is not available or if the person is not adjudicated, but they're not able to make decisions for themselves and they do not have a next of kin. There would be a need to go to probate court, but in certain emergency situations, the commissioner or designee can make changes or consent to emergency medical treatment. But this does not apply to changes in code status. So the commissioner and no one else has the authority to change a person's code status. Now, I say that, but there are rare circumstances where a person may not be adjudicated and they don't have a healthcare representative appointed, they're not able to make decisions and they may be actively dying or they may be terminal. And usually the process is to go to probate court and to have an emergency medical guardian appointed. And while we are waiting for that, at times, I think in the 32 years that I work for the department, I believe it's happened twice that our legal director gets involved with the process, and we were able to consent to a change in code status because it was an emergency and there was a court date pending. But that is rare, and that is not generally not within the scope of what commissioner designee can do. And the DDS DNR review process. So DDS is responsible for reviewing DNRs that meet the criteria in accordance with Connecticut General Statute 17A-238G based on the supporting medical documentation. And DDS does not authorize a DNR order. What we do is say that the DNR, the person's condition and the DNR documentation that we have reviewed meet the criteria for a DNR order, but we are not implementing the DNR or authorizing a change in code status. Once we say that it meets the criteria, then the physicians or the healthcare providers, whoever's involved, they can go ahead and change the code status. DNR orders shall not be implemented before a DDS DNR review is completed for those individuals for which it is required, and I will specify who it is required for. So usually the hospital, a hospital social worker or a DDS case manager or nurse or someone will initiate a request for change in code status. However, in rare cases where a DNR has been implemented and we have not reviewed it, we do not have them rescind the DNR. What we do is usually the regional health services director will get in touch with a physician, a social worker, or a nurse at the hospital or facility and have them send us the appropriate documentation as soon as possible. And they will usually do that. Sometimes they rescind it when they realize they are not in compliance with legislation, but we do not require them to rescind it. We just have them send us the appropriate documentation. And the DNR order does not mean that an individual is no longer treated. So they continue to receive care and appropriate treatment for other issues. So for instance, if an individual has a DNR in place due to cancer and they are in the final stages of the disease or there isn't any other treatment that they will benefit from, but the person ambulates and they fall down the stairs and they break a leg, they would still need to go to the hospital and receive emergency medical treatment for that injury. However, if during the course of that injury, something were to happen or they code it, they would not be resuscitated during the course of treatment for that. Now, we do have people who have DNR orders in place and they need surgery or they need some procedure. And what they will do is rescind the DNR or put it on hold temporarily so that they can get whatever surgical treatment they need. And then once they come out of recovery, the DNR order is then implemented. That doesn't happen that often, but that is another possibility and an option. So the review process requires the Regional Health Services Director in collaboration with the Regional Director to complete the DNR review. And it falls under the Regional Health Services Director as opposed to the Director of Nursing for Public Programs, because some individuals will reside at DDS residences, and then they might later transition either to home, to a skilled nursing facility, or to another residential home supported by a DDS funded qualified provider. When that happens, if the Director of Nursing for Public Programs were to oversee the DNR, the person could transition and that Director of Nursing might not know, and they would not be able to say, oh, did you forget this? Or don't forget the documentation regarding the DNR. But the Regional Health Services Director is in communication with qualified providers, the private providers, and all of the individuals. So if somebody leaves a public program and goes to private or independent living or something, the Regional Health Service Director would still have involvement with that individual and some oversight. So that is why the Regional Health Services Directors oversee all DNR orders for whichever region the individuals reside in. And Southbury Training School follows the same process, with the exception that they initiate their DNR review. The physician at Southbury Training School will initiate the DNR reviews, and in that person's absence, it would likely fall to the West Region Regional Health Service Director, and sometimes they may do it in collaboration. But Southbury Training School Medical Director and the Regional Director would oversee those DNR reviews. And then the Director of Health and Clinical Services, in collaboration with the Commissioner, would complete a secondary review. And those reviews are required if the person is a DDS class member or if they reside at Southbury Training School, because people who reside at Southbury Training School are considered as class members, even if they were not there during the time that there was legislation identifying class members, that there was a legal settlement in which we identified class members. If they reside at Southbury, they're still considered a class member, whether they were there at the time that the class member designation was initiated or not. And then in cases where death is not imminent within days or weeks, so if you don't think the person is going to die within days or weeks, then it requires a secondary review by the Commissioner and the Director of Health and Clinical Services. It applies to all adjudicated persons. Adjudicated, again, means that they have a legally appointed representative or guardian, and they're placed in the care and treatment under the direction of the DDS Commissioner. So if the person lives at home with their own family and a parent or someone is a guardian for them, they would not necessarily be required to go through this process. If they don't reside in a DDS funded residence, they would not be considered as under the treatment or care of the DDS Commissioner, except if they attend a day program that DDS funds, then they would be required to undergo that review. So it applies to anyone who's adjudicated, all DDS class members, individuals residing in residential homes that are operated, licensed, or funded by DDS. If they reside in an intermediate care facility for individuals with intellectual disabilities, that would be our ICF locations. And then individual home supports, community companion homes, continuous residential supports, or if they attend a DDS funded day program or any of the respite centers, and if they are residents of a skilled nursing facility or long-term care facility, if they were placed by DDS. So if they went into a skilled nursing facility from their own home or family home, their review would not be required. But if they went from independent living where they were supported by DDS, or a DDS funded residential home or ICF residence, then they would require that DNR review. And most of the skilled nursing facilities and hospitals are aware of our process. There was a time when I was in the North region, and myself and one of the nurse consultants, Trish Lilly, we reached out to all of the hospitals in the North region and the trade center at Department of Public Health for skilled nursing facilities, and did brief presentations on the DDS DNR review process, why it's required, and what they need to do so that they would be aware of it. So most of the hospitals, at least in the North region, should have that information and be aware of it. And I'm going to say that I believe the same thing occurred in the West and South regions as well. But I was part of it in the North region, so I know that it occurred. Then exemptions for DNR reviews. If an individual has a valid advance directive or living will, and we say valid because sometimes if a person goes into a hospital, the hospital will allow a family member or a parent to sign advance directives. And advanced directives or living will can only legally be signed by that individual. So nobody can sign an advanced directive or living will for anyone else. You sign it for yourself. So if they're not capable of signing it, then they would need to have a guardian and go through the DNR review process. But if an individual signs advanced directives or establishes advanced directives or living will for themselves, while they are able to make that decision and they're not adjudicated, it lasts for the duration. So if they later end up in a group home or residential home, or that living will stays in place, and we honor their wishes because it is the at least that we can do to respect the wishes that they outlined in advance. The the only gray area would be on the advanced directives, and there should be one in your packet, but I'll show you one on the screen. There's a section where they can say, it'll say something like, I want or I wish to receive intravenous fluid, cardiopulmonary resuscitation, artificial ventilation, artificial nutrition, or hydration. If they check yes to everything, meaning they want everything done, their advanced directive says they want CPR, they want artificial nutrition, they want to be on a ventilator, they want everything done, then their advanced directive or living will should also indicate that they have appointed a healthcare proxy or a healthcare representative. And this is somebody that when they are no longer able to make decisions, that person would say, okay, the doctors have done everything. There isn't anything else, and we're going to go ahead and change the code status. Otherwise, you couldn't change their code status. They would continue to receive aggressive treatment or some type of treatment until they just die, because eventually that's what would happen. So those are the only cases. And so I do encourage anyone who has advanced directives or living will to also appoint a healthcare representative. And when teams meet annually, they should be checking to make sure whoever that representative is, that person is still alive and that person is still cognitively able to make decisions for somebody else, and they have not suffered some type of cognitive decline on their own. Because sometimes when we need that representative, it turns out that they passed away or their contact information has changed and nobody knows how to reach them, or they themselves are not able to consent to treatment for anyone. If they're not adjudicated, that's an exemption. They have no legal guardian or representative. Individuals who live with their families or in individual family support. This includes children that might be voluntarily participating in DDS behavioral support program or services, individuals that are placed in a skilled nursing facility for long-term care on their own. So we do have people who decide they want to transition in long-term care. Like sometimes it's a couple, a married couple, or a couple that, if Connecticut honored common law marriage, we would see it that way. So that would be another exemption. And people who are eligible for DDS services, but they decline to receive DDS services. DDS services are voluntary. We don't have services that people must have. There are certain cases where a person is appointed by a judge. They are DDS is assigned care and custody of that person. So those people are different, but otherwise our services are voluntary. People voluntarily accept our services and they can voluntarily decline them. And this also includes over-registrants. They are exempt. This would be people like persons with traumatic brain injuries that aren't, they don't qualify for DDS services, but they're in a skilled nursing facility and they are considered as an over-registrant. So we have nurses, over nurses, and over stands for Omnibus Reconciliation Act. I believe it was 1986. 86 or 87, but it has to do with people being placed in skilled nursing facilities and not being left there, just no follow-up, no care, no coordination. So it requires some follow-up and coordination on the part of DDS and other individuals. And who can request a DNR? We have healthcare providers in the community, like a person's primary care provider might say, this person really should have a DNR. It could be healthcare providers most often at the hospital, and they've determined that somebody's condition has deteriorated, they have a poor prognosis, and they really are not a candidate for continued aggressive treatment. And then the individual or their legal guardian can request the process. Again, if it's the individual, if they're not adjudicated, they would follow through with advanced directives or a living will. And we encourage them to do so as early as they can. So if they're 18 or 20 or whatever age, to establish this. And very often people don't want to have this conversation. And it can be a difficult conversation, but I will talk about some ways that you can have that conversation and encourage people to do so. And people can voluntarily appoint somebody, a representative. If they don't want to make that decision, there is a document where you can appoint a healthcare representative, a proxy, without identifying, a living will or advanced directives. If the person's condition doesn't meet the criteria, it can be documented in their chart, their wishes. So we will have sometimes an individual or a family member. It's usually a family member, like a parent, and it may be the person's mother and their father's already deceased, and maybe they have some siblings or no siblings. And that parent is really worried that they will die before their son or daughter does. And then they worry about their end of life care. So they want to put a DNR in place before the person before they die. And if they don't meet the criteria, if they don't have a terminal irreversible condition, they cannot put that DNR in place, but they can document that and we can keep it in our records so that later, when it comes up or when there is a guardian appointed or when, the person does develop a condition for which they are eligible for a DDS DNR review, then we have that documentation. And we've also had guardians who don't want to support a DNR. So the person may be terminal and a DNR may be in their best interest, but if they have a guardian and that guardian does not want to put that DNR in place, it doesn't happen. We can still complete the review, but there under the comment section, it will specify that the DNR cannot be implemented until the guardian or their representative is in agreement. So we've had those cases. And then we've had individuals who don't want a DNR, and you can have an advanced directive and then decide to add a DNR to it. And we've had some individuals where it's recommended. They might have an aggressive cancer that there is no cure or they've exhausted treatment and they are still able to make decisions, but we know they will get to a point where they may not be able to. And sometimes they still will not agree to it. And if they appoint a healthcare representative and then their advanced directive or living will specifies that that person shall or must follow their wishes, and if they wish to have treatment, the maximum treatment to have everything done, then that representative has to go to probate court to change that in order to change their code status. So we've done that as well. So ideally, when people are completing advanced directives or a living will, the best thing to do would be to tell them to appoint a healthcare representative or proxy and allow that person to make decisions on their behalf, rather than to say that they have to follow their wishes. And initiating and completing the DNR review process. So it's usually the case manager or a team nurse who becomes aware that there might be a need for a change in code status or there is a conversation. That person will usually notify the appropriate regional health services director or director of nursing for DDS public programs. When they notify the director of nursing for public programs, they also either they will or the director of nursing will notify the regional health services director, because that's who is going to be finalizing that document. And they will share contact information with the regional health service director for the regional health service director with either the hospital, the physician, the APRN, or some other medical professional or skilled nursing facility. Sometimes it's a case manager or social worker at the facility or the hospital. Then the case manager or the nurse provide the regional health service director with the most recent nursing summary from the individual's IP or their most recent quarterly review. This provides an outline of all of their diagnoses and all of their treatment. So it should have their medications, their allergies, whatever medical conditions they have. And those are valuable when the regional health services director is it's reviewing the DNR documents. And then the Regional Health Services Director, if needed, will share. DDS has a DNR frequently asked questions FAQ document that we've outlined, what's required and the process to follow. And then it has at the bottom of it, it identifies who the Regional Health Services Director is for each region. And I don't believe Southbury Training School is included on that, because anytime an individual from Southbury has a change in condition or goes to a hospital, or rarely a facility, a skilled nursing facility, but if they were to, the physicians, the medical director at Southbury would be aware of it, and so would the interim nursing director. So they would be aware of it already. So their contact information isn't on that list because they're already involved. And then when the DNR review is finalized and signed by the regional director and or the director of health and clinical services and the commissioner, if appropriate, then the regional health service director will usually notify the case manager and the nurse and share that document with them. They will also share it with the hospital or the facility if the person is in the hospital. And it should be shared by the team nurse or case manager with the individual's primary care provider and any other healthcare providers that are involved with that person. And once the hospitals have it, they usually will keep it in their record so that if the person is hospitalized again, they have that on record. And a secondary review is required by the Director of Health and Clinical Services at Central Office and the Commissioner. If the person is a DDS class member or resides at Southbury Training School or previously resided at Southbury Training School, and if death is not imminent within days or weeks. There are times that a regional health service director might request the commissioner's signature anyhow, and we've usually complied, but it really is not necessary, and it shouldn't be requested if it's not necessary. Sometimes there might be certain circumstances or situations or concerns, and it might not meet this criteria, but for some other reason, the commissioner reviews it and the director of health and clinical services will review it. And the process is the director of health and clinical services will review it. They will say, yes, I agree, the secondary review is required, or they might say, no secondary review is required, and that's it. And then if it's required, it is the director of health and clinical services at central office who then contacts the commissioner or designee. In the commissioner's absence, it is usually the deputy commissioner who steps in to sign. And there are times when the director of health and clinical services might feel that it is warranted for the director of legal and governmental affairs to review it. In this case, it's Attorney Marjorie Wakeman. So that person would provide an additional review. And there is a small section on the bottom of our DNR review form to indicate whether someone from legal reviewed it, and that person would also sign and date it. This is the form, and this form, it is a review. It used to say, do not resuscitate DNR order. And hospitals and skilled nursing facilities would think that it meant that this was the order, that the person had to order. So in order to change that misperception and eliminate any confusion, we added the words review of. And so this is the document, and it is fillable. It is only to be completed by the regional health service director, or in their absence, their designee, and then the director of health and clinical services and the commissioner might sign it, and the regional director. It should never be shared with private providers or hospitals, because we've received the form where a healthcare provider has filled it out, or a nurse or someone else, and that is not acceptable. It is a document that's internal to DDS, and only DDS should be completing it. Once the regional health service director has completed their review, and then they determine that it meets criteria, they will notify the hospital that it meets the criteria, or the healthcare provider or the nurse or whoever's involved. They will say, yes, it meets criteria. And then they will get the documentation. In some cases where the person might be actively dying, then the regional health service director can call the hospital, or we will usually send them a fax or email a document. And there's a letter that we have that says it meets the criteria, that the person's medical conditions and prognosis meets the DDS DNR criteria, and they may go ahead and implement a do not resuscitate order. DDS's authority is only limited to DNR orders. So once we have implemented a DNR order, or we have said that the DNR order meets criteria, it is then up to the healthcare providers and the legal representative of the person to then decide whether they want to do not intubate, comfort measures only, medical orders for life-sustaining treatment, or do not hospitalize. And no additional review is required by DDS to do that. We only review that the DNR meets criteria, and we give them the permission, I guess, or the approval that it has met criteria. And then they take it from there. And for people who are not familiar with medical orders for life-sustaining treatment, it is a MOST is the abbreviation. Those are things that are implemented when the person is actively dying, and it is end-of-life care, what the person wants, and a guardian or a family member may be able to state that. So DDS doesn't review that. We don't get involved with that. We only review the DNR, and then they can follow any other processes after that. Every now and then we will get a request to make somebody do not intubate or do not hospitalize, and we cannot do that without first reviewing a DNR and implementing a DNR. So that has to come before any of the other things. But on the other things, DDS rarely gets involved. Occasionally, we've gotten involved when someone had a DNR order in place, but a guardian or a family member wanted to discontinue like antibiotic treatment. And antibiotic treatment would have made the person more comfortable because they had an infection, or the person might be on enteral feedings, tube feedings, and someone wants to stop the tube feedings because they feel, okay, the person should be allowed to die. But if death is not imminent and they are getting appropriate nutrition, we have intervened to say, look, there isn't a reason to stop nutrition at this point. And it's usually for somebody who's been receiving enteral nutrition, like they've had a G tube for a long time, or a J tube, not somebody that is at the end of their life and there's a decision whether to insert a G-tube or not. So in those cases, if the person has a DNR order in place, there would usually be no reason to insert a new G-tube or gastrostomy tube. I apologize for using abbreviations. I'm trying not to, out of respect that people might not know what I'm talking about. But occasionally we will intervene on that behalf, because if you stop nutrition and hydration, the person is going to die. And if death is not imminent, it does require secondary review. And once the secondary review is completed, then the regional health service director gets notified by the director of health and clinical services at central office, and then they go ahead and follow through. We will get DNR requests in the evenings, after hours, on weekends, on holidays. Although we encourage nurses, case managers, and anyone else who may be involved, that if they see or can foresee that somebody's health is declining or they may need a DNR, to try to get that process moving early, so that at the last minute, we're not getting a call that somebody's actively dying and they want to put a DNR in place. And we will get those calls, because hospitals understand that if the DNR review process has not occurred, they are not going to change the code status. Because if they do, they will get notified in writing after the fact that they violated the legislation, that legally they are required to follow this. And when I was North Regional Health Service Director, I got a call at like 11 o'clock at night about a DNR at a hospital. And I said, the person is required for review, and this is what you can fax me. And I had a fax at home, but I also was able to receive and send faxes through my DDS computer. And the physician said, no, we're not going to do that. The guardian is here, and we're going to just change the code status. So I said, you can't do that. And I faxed over the legislation and the FAQ and a note saying this is required. And then about 3 o'clock in the morning, I got a call saying they were sending me the documents. What I had done already was, in anticipation of it, I started filling out that DNR review form. Or sometimes I'll start drafting a letter that says it meets the criteria, but it's a weekend or a holiday, and the form will be sent, on the next business day. And I still send it even if the person has passed away, or if they're no longer hospitalized. We still send the form so that they would have a copy of that. And then this form, there is a form. There are DNR bracelets that once a person has a DNR, we try to get a bracelet for everyone. And it's usually these plastic orange bracelets, but there are some metal ones. But we just buy in bulk the plastic ones, so that when somebody needs one, we should be able to get it from public programs, and just have their name put on it. And it's supposed to be attached to their arm, their wrist, or their ankle. But because of pica, and because some people could have a DNR order in place for years, and you wouldn't want them to have this thing on them for years, or it might get broken or lost. It can be taped to their bed or to a medical binder. And then when they go to a hospital, if they are transferred via ambulance, they require the bracelet and this form. Without it, the EMTs will not honor DNR orders. They will resuscitate the person. So they have it, and then EMS will provide it to the hospital. Emergency medical technicians or emergency medical services, they will provide the document with the hospital. And people coming from the hospital will often, we should be getting this transfer of DNR, do not resuscitate order, and the person should have a bracelet on. If they don't, we will usually put it on them once they're at the residential home. Then this DNR review form is required, and it's completed by usually nurses, but it can be completed by case managers. Usually if the person is in a skilled nursing facility. This form just says on a quarterly basis, every 3 months, that yes, the DNR order is still in place and their condition hasn't changed. If their condition were to change, so let's say somebody had a DNR order in place and then uh, do not intubate order is put in place. So, or do not hospitalize or comfort measures only. That's a change. So they would date it, they would check change, and then they would indicate what the change is. Or sometimes a person will have a DNR order put in place at the hospital and it looked like they were going to die, like their condition was terminal, but they didn't. They survived. If they survived and they no longer have that terminal condition, which would be something like septic shock. With septic shock, the person is usually going to die. It means they have an infection and it's in their blood system and their body is shutting down and they're going to go into multiple organ failure or multi-organ failure. If for some reason somebody recovers or does well, that would be a reason that if the DNR order was put in place due to septic shock and they survived and they came home and they don't have an irreversible terminal condition, then we would resend it. And sometimes a family member will say, well, when they're back at the group home, I want it rescinded. I want them to receive CPR at the residential home. So it could be rescinded, and you would just date that and indicate it, because sometimes what happens is the hospital will have a copy of the DDS DNR review form, but it's been rescinded and they don't know that. So they're assuming that it's still in place. So we provide that documentation and it is sent to the Regional Health Services Director. There is a DDS DNR database that all of the Regional Health Services Directors have access to, and they update it. They will add people that have DNRs. They, in the North region, I would add people that had advanced directives, and I believe Stacy Dawes, who is the current Regional Health Service Director for the North region, I believe she does that as well. I can't speak for the South region or the West region because I'm not sure, but they should be doing it. You should include advanced directives and living wills so that if a person goes to the hospital or they're at the end of life, we have a copy of that and it can be provided to the hospital. It's in their record and it should be in our database, because on a weekend or on a holiday when there's a need to change the code status, sometimes the person already has a DNR review and the hospital isn't aware of it or somebody isn't aware of it. Or sometimes we'll get other situations where we might need to do a review, or um, skilled nursing facilities. So there was a fire at a skilled nursing facility at one point, and we needed to know how many people we had that were in that facility. So we have a database for that, and we have a database for DNR. So we know that if somebody has a DNR, and it should be kept up to date. And so the quarterly review is then whoever completes it, it will be a case manager if the person resides in a skilled nursing facility or a hospital, like hospital for special care, where they could reside for years until they pass away. And if a person is in hospital for special care, which is not considered a skilled nursing facility, but it's a specialized facility, it's a hospital, if they were placed by their family. So if they went from a family home to that facility, they are usually exempt from the DDS DNR review. There are some exceptions because most of the time, if a person goes from home, it will be a child who goes from home to hospital for special care and then they become adult. But we would not have oversight over them because they were placed by their family. If it is somebody that is attending a DDS day program or getting day program services at the hospital that DDS is funding, and they might stop breathing or need CPR or and shouldn't have it, then we would do the review because we need to, and it usually is just a matter of the hospital sending us documentation. And we complete the review and just say that we're aware that a DNR order is in place. It was implemented by a family member. The person is receiving day services or whatever, and it meets DDS DNR criteria. And upon the death of an individual, this form and all other DNR documentation become part of the person's permanent record. there was something else I was going to say about that, but I lost my train of thought. And if it comes back, I'll mention it. This is the contact for all of the regional health services directors. They should be updating this if anything changes. And I see that a lot has changed. So I'm hoping that they have an updated one in terms of the regional directors, because Elisa Velardo is now our deputy commissioner at central office for all of DDS. And then the South region and the West region regional directors have changed. So that information needs to be updated. So hopefully they have a copy, or they can get a copy to you that's updated. I went through the slides before the presentation, but didn't pick that up. So sorry about that. Advanced directives and living wills. So once again, only the individual themselves can establish advanced directives or a living will, and it states what they wish, what they want in terms of medical treatment and end of life care. And it's honored in even when they are no longer able to make those decisions. If this is in place, it will be honored. And they should identify a healthcare representative or proxy in their advanced directive or living will. But there's a separate document that they can do it. And this person makes decisions when they're no longer able to do so. It is not required to be notarized, but if it's being done by someone at DDS, there should be a witness, and that witness should not be the person that they're identifying as a healthcare representative or proxy. It also a staff person, somebody who works directly with that individual, or is the nurse for that individual, or case manager, or somehow involved with that individual through DDS. Unless that person is a blood relative, that no DDS employee should be signing it if you have a relationship with that individual in your employment. It may be that somebody transitions to a private residential home with a qualified provider, and they might have had a really close relationship with somebody who worked for DDS, a case manager, a nurse, a developmental services specialist, a psychologist, somebody, and they want that person to be their representative or a proxy. They can do that as long as that person is not currently working with them to have some involvement in their care. Then it is a conflict. They may be notarized, but they don't have to be notarized. And who can establish? So only people who are not adjudicated can establish advanced directives or a living will. Once it's established, it remains effective, even if they later become adjudicated and have a healthcare representative or guardian. The signed advanced directive or living will should be distributed to the primary care provider, the appropriate DDS regional health services director. The case manager should have a copy, and the individual should have their original copy. Some individuals will give their original copy to a family member or a healthcare provider or someone, but usually the person would have their original copy on their person. And then if they're hospitalized, it should be shared with the hospital on admission. And then the hospital will usually keep a copy of that record. It should be reviewed again and revised if needed. It should be reviewed annually and revised. The revisions might be, somebody might have said that they want artificial nutrition, and later they might decide, you know what, I don't want a G tube. I don't want a gastrostomy tube. I don't want tube feedings. I don't want IVs. I was always afraid of needles. I don't want an IV in place. So if they change their mind about certain things, they can revise it and redistribute it. They are exempt from the DDS DNR review process most of the time. One exception that I can think of is if the person was a class member, but they were not adjudicated and they established advanced directives, and but they're still a class member, we would still review it, and the review would indicate they had a living will in place and their living will or advanced directives are being honored. And it gets signed by the regional health services director, the regional director, the director of health and clinical services at central office, and the DDS commissioner. So it's very rare that we would review, do the DNR review process for somebody with advanced directives or a living will. There have been times that we completed a review because we didn't know they had advanced directives or a living will, and then we get notified later. And then there is a website, I think that's the website for like a blank advanced directive. And we should all have one for ourselves. And I certainly have one, and my husband has one. And, mine says what I want. And I've identified a healthcare proxy. My husband says that he wants everything done. And when everything that is possible can be done, then it's okay to let him die. And I've always jokingly said to him, well, I will honor that as long as our health insurance is covering whatever the procedures are. But once there's no coverage, I'll pull the plug myself. But it's just, just to make the point that we should all have something in place. And you hear about it on the news, you read about it, famous people who have a lot of money, but they have never established who should deal with their finances and their health care. And so it really is important to just think about these things up front, especially if people have minor children. And this is just another part of that document that if people want to donate body parts, they can. And we do have individuals that we support who have decided that they will donate body parts. On certain conditions, if people have certain genetic disorders or other conditions at the time of death, sometimes even though they want to donate, their donations are not accepted. And we usually don't tell them, the hospital might let us know, but we don't say to the family or the individual. They just don't take any body parts, that's all. And then other questions that have come up when we've done this presentation is the difficulty in having this kind of conversation. And it is difficult. The nurse should be comfortable, whoever the team nurse is. And if that person isn't comfortable, then one of the regional health services director or somebody, usually in nursing or the medical profession, should be comfortable. But it can be a team discussion, but it is not a team decision. And we will get teams that say they don't agree with the DNR, and they don't have to agree with it, but that doesn't mean it doesn't go ahead and move forward. So it's not a team decision. The decision is, if the individual is adjudicated, it is between their guardian and the medical professionals once we've determined that it meets criteria. So, people can have opinions, but it is not a team decision. It can be a team discussion, but it's not a team decision. DDS has a legal responsibility to provide this oversight, and so that is why we do it. And we do review it. Sometimes there will be somebody who they might have anatomical features or contractures or things physically where like they're contracted, or you can't do chest compressions, but they could benefit from rescue breaths. So we have done the DNR review and indicated the person may not have chest compressions, but they can receive rescue breaths, or they may or may not be intubated, but chest compressions would likely cause more damage than help them. Because if it's somebody with a bone disease, brittle bones or fractures or a genetic disorder, and you do chest compressions, you can break their ribs and have a rib puncture the lungs or some other organ. So we have done that. And then do not intubate orders. Usually they're in the hospital, and they won't be intubated and placed on a ventilator, but they can still, we still would review them. You have to review the DNR first before you implement do not intubate and other things. And once it's reviewed, it's up to the guardian and the healthcare providers to make all other decisions. Any changes to the DNR review process related to COVID-19? So in 2020, early on, we had hospitals that reached out to us, and they usually contacted us at central office to say that they wanted to change two things. One, if the person had COVID-19, they wanted to automatically put a DNR order in place. And the other thing was they wanted to waive the requirement for 2 physicians or nurse practitioners to make that decision together. And at that time, our Director of Legal and Government Affairs was Attorney M.J. McCarthy. And her and I were in meetings with the hospitals, and some of the regional health services directors were also involved in some of those meetings. I believe Stacy Dawes was involved in at least one of the meetings that we had with the hospital. But we did try, Attorney McCarthy drafted some changes with the legislation. It was presented to, I believe it is the Office of the Attorney General, and it just didn't go forward. We could not make those changes, so it just didn't happen. So there were no changes to our DDS DNR review process based on COVID-19 pandemic. And non-adjudicated, they don't need a review. Now, we may have people that don't have a guardian, and they should, so they should be adjudicated, but they are not. When that happens, it's usually the case manager, and they're usually in a hospital or facility. They will contact probate court and try to get an emergency healthcare representative appointed or guardian to make decisions on their behalf. And sometimes it's a quick process and sometimes it's not. And hospital staff should be educated on the DDS DNR review process, because we've gone out, and Department of Public Health, before the pandemic, they met with the executive directors for skilled nursing facilities, nursing homes, and I don't know how often they met, but it was under a group called the Trades Group. And there's also the Connecticut Hospital Association. So we went to the Trades Group when Lakeisha Hyatt was our Director of Health and Clinical Services. We met with the Trades Group and educated them about this process. So all skilled nursing facilities should be aware of it. And we've also met with the Connecticut Hospital Association, so they are also aware of it. And then if a person is not under palliative care or hospice, but needs a DNR in place due to terminal diagnosis or comorbidities, but the healthcare provider won't write the letter, we do get healthcare providers who say, I'm not going to do it. They don't feel comfortable. And it's usually because of the legislation. They feel like if there's something legal about it, I don't want any part, because if I make a mistake, I don't want to be blamed. But that's rare. And usually the legal advisor for the hospital or the facility will read the document and let them know that, yes, you can go ahead and sign. But sometimes you have to get another healthcare provider that's involved with that person's care to sign off on it. And usually the regional health services director can be helpful in reaching out and clarifying any misunderstandings or helping with that. And again, if the advanced directives or living will state they want to be a full code, when they've received everything that they can receive, at that point, the healthcare representative would just decide either the hospitals will allow them to make a decision or they go to probate court. And we share the DNR FAQ, and we've also been involved in probate court hearings. So that is the DNR review process, and I will stop sharing.